disqualification. They are invariably saying that by the mere fact that Obi left PDP on a certain day, I think 26th of May 2022, and joined the Labour Party 27th of May 2022, and took part in the presidential primaries of the Labour Party on the 30th. You know, the provisions of Section 29, subsection 1.
So guys, we all know that the APC has come out to say that Peter Obi is even not qualified to have contested for the presidential position. They also allege that Peter Obi was a member of the PDP, and at the same time he moved to the Labour Party and clinched the presidential ticket of the Labour Party. Apart from that, INEC has equally asked the court to throw away Peter Obi's petition that they lack merit. So guys, in today's video, we have a constitutional lawyer who has come to, clear the air on all these issues. So I would advise you to stay tuned, take your time, relax, and just listen to what he has got to say, if Peter Obi is qualified or not. And also, he went further to talk about Shettima, the vice presidential candidate for the APC. We all know that Shettima had 2 nominations. He was nominated for a senatorial seat. He also participated as a vice presidential candidate. So guys, all these issues, we are going to look into them. So just stay tuned and let's digest all of this. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section below. Thank you.
They were starting with Barrister Abdul Mahamood. Is it barrister, or is that the title?
It has become a normative practice in Nigeria.
Okay.
I'm tired of correcting people. Okay. Barrister is not a title. So I'm simply Abdul Mahmood Esquire.
Oh, okay. So that thing that lawyers always add, it's like some of them, if you don't add the barrister, it's almost as if you've committed an offense. So thank you for that correction. So today we have Abdul Mahmood Esquire. He's a Nigerian lawyer, a social critic, columnist, human rights advocate, knowledge worker, essayist, poet, former students' union leader, and activist. I mean, when student unionism was at its peak, these are the people who led student unionism. He's currently the president, Public Interest Lawyers League, PILL, a body of professional and independent group of lawyers committed to the promotion and enforcement of the rights of vulnerable and minority groups, the deepening our democracy and governance, and the expansion of public interest law. He is a third-generation Nigerian poet whose works appear under the and today it's going to be quite interesting. We're having 2 guests. Our topic for today is Nigeria's presidential election 2023, analyzing respondents' brief. That's what we are going to be doing today. And we thought for now we're going to have 2 guests. But we're starting with Barrister Abdul Mahamood. Is it barrister, or is that the title?
It has become a normative practice in Nigeria. Okay. I'm tired of correcting people. Okay. Barrister is not a title. So I'm simply Abdul Mahmood Esquire.
Oh, okay. So that thing that lawyers always add, it's like some of them, if you don't add the barrister, it's almost as if you've committed an offense. So thank you for that correction. So today we have Abdul Mahmood Esquire. He's a Nigerian lawyer, a social critic, columnist, human rights advocate, knowledge worker, essayist, poet, former students' union leader, and activist. I mean, when student unionism was at its peak, these are the people who led student unionism. He's currently the president, Public Interest Lawyers League, PILL, a body of professional and independent group of lawyers committed to the promotion and enforcement of the rights of vulnerable and minority groups, the deepening our democracy and governance, and the expansion of public interest law. He is a third-generation Nigerian poet whose works appear under the I'm lost. Get me pronounce that part.
It's nom de guerre.
Okay, nom de guerre. Is that Obemeta? Obemata?
Yes, Obemata.
Okay, Obemata. Some of his poems have also been translated into Polish, Lithuanian, and French languages. He attended the Federal School of Arts and Science, Ondo State, and later the University of Jos Plateau State, where he obtained his Bachelor of Laws, LLB honors, and then proceeded to the Nigeria Law School for his Masters of Law, LLM. Thank you so much, Abdul Mahmoud, for joining us today, Abdul Mahmoud Esquire, for joining us today, and to also share with us what this brief is all about. Here, we are here to learn, we are here to understand more, and we are looking forward to hearing from you. So the first question I'm going to throw out there is that we've gotten the respondents have brought in their briefs, both from INEC and then APC presidential candidates. What do you make of it? Can you give us like an overview of what those briefs are all about? Can you hear me? You're frozen. Hello? Okay, I think there's a bit of technical issue from, okay, he has dropped off. I think there's a bit of a technical issue. So we'll look, while we wait for him, for all of us that are joining, well done and good afternoon. And for us, this is going to be another learning moment. If you're on and you want to say something, please go ahead while we wait for them to come in. Go ahead, please, and make a request. Let's hear from you. We've seen the response have come in, and a lot of people have put out a lot of things out there. But one of the things that we're very sure of right now is the fact that on the issue, the Tinubu's camp is no longer denying the issue that $460,000 was actually forfeited. So the issue of forfeiture is no longer the one that people are saying they don't know anything about. Yeah, Abdul Mahmoud Esquire, you're back on, right? I can see you. Can you unmute yourself?
I lost you briefly. I'm sorry, because of the network.
Yes, the network has been. So the question was that, can you please give us like an overview? We've seen the respondents, they've brought in their brief. Can you give us an overview of the INEC and also the APC response to the petition that has been served to them? Straight
up, we cannot have an appreciation or understanding of the respondents' reply to the petition of the Labour Party and Obi if we don't understand the government, the very foundation, the very heart of Obi's petition. So the starting point for me is what is constitutive of Obi's petition filed before the PET in Abuja. Obi's petition is founded on two fundamental planks. One, the qualification or disqualification of the president-elect or presidential candidate of the APC, Alhaji Bola Ahmed Tinubu, at one level. These ground of Obi's petition is founded on Section 137, 1D of the Constitution 1999. In the course of our conversation, I will go into what 137 is all about. And two, the disqualification, if you like, of the vice presidential candidate or vice president-elect of the APC, Alhaji Shettima, more particularly as it relates to the issue of double nomination as provided for in Section 35 of the Electoral Act. And the second fundamental limb or plank of Obi's petition is founded on the whole argument about the non-substantial compliance of INEC with the provisions of the Electoral Act as it regards the conduct of the February 25th presidential elections. While the second one deals with facts and law, facts and law, or what lawyers call mixed facts and law. You cannot say elections was not, the conduct of an election was not in substantial compliance with the law if you don't found your argument around facts. What are the facts? That elections took place across the length and breadth of our country, on that particular Saturday. Elections were returned in certain polling units across our country. Elections were not returned. Elections were rigged. When you bring criminality into the whole question of election petition, you are raising the bar. And the strictest proof will be on you who is alleging criminality. That's the second limb. But the first limb is not a matter of fact, it's a matter of law. It's a matter of law. It's a matter of law. And the position of Obi is founded on the whole question of forfeiture that took place in America 29 years ago. The whole business of white powder trafficking and all that. And the order of court of the Illinois court in Chicago that made the order of forfeiture. The argument here is this: does forfeiture fall within the ambit of Section 1371D of the Constitution? The Constitution does not in specificity refer to forfeiture. It talks about fines. It talks about fine. Can fine mean forfeiture? But we have seen Supreme Court decisions placed in the public space in our country, particularly the Supreme Court decision in which the CJN of Nigeria, Justice Ariwola, read a lead judgment where he basically quoted forfeiture around the whole context of fine. When you forgo something, it comes within the whole business of fine. So that is the entire argument of Obi. But if you look at Section 1371D, and I have always made the argument that the disqualification grounds in Section 1371D is not one. There are 6 disqualifying grounds because each ground is separated by the conjunction or, where it says fine, it says or fraud. When it says death sentence imposed by any court, it says or tribunal. So if you count the number of us in subsection 1D of Section 136, you are looking at 6 disqualifying grounds. Then if you move further to subsection 1E, where it talks about, the question of fine must have been imposed between a period of 10 years preceding the elections that presidential candidate is expected to run. And if you look at the beginning of Section 1E, for those who have the Constitution there, the last word that separates 1D from 1E is a semicolon. It's a semicolon. And after the semicolon, it begins with or. So what that means is that Section 1E, the disqualifying ground in Section 1E is separate from those 6 disqualifying grounds that are outlined in subsection 1D of Section 137 of Section 137. So having this in view, I have to go to the reply or the respondent reply.
Yeah.
The APC response comes in the form of a PO, what lawyers call a PO, preliminary objections. Preliminary objections. What they are doing is contexting the legal grounds in which Obi's petition is founded, and also raising their own grounds of disqualification. They are invariably saying that by the mere fact that Obi left PDP on a certain day, I think 26th of May 2022, and joined the Labour Party 27th of May 2022, and took part in the presidential primaries of the Labour Party on the 30th. You know, the provisions of Section 29, subsection 1, you know, which deals with the submission of names of candidates of political parties, and Section 77, subsection 2 and 3, which deals with the register of members of political parties, and the time frame within which these political parties are expected to submit this register to INEC. Where Section 29, subsection 1 talks about 180 days, Section 77, 2 and 3 narrows the time frame to 30 days for submission of register of members to INEC. The contention of APC is that as at when Obi left PDP on the 26th of May, 2022, the register of members of Labour Party had been submitted 29 days prior to when he left. So he was not a member of the Labour Party as at when he ran as an aspirant of the presidential primaries of the Labour Party. So that is one limb of the argument to knock the bottom out of the argument Obis lawyers have posed in their petitions before the tribunal. For a lawyer who is the that there is a gulf between the Electoral Act, which is an inferior legislation to the Constitution, the issue of qualification for presidential candidates, are stated in Section 131 of the Constitution, specifically Section 1C, subsection 1C of 131, which says that for you to become the president of Nigeria, you must be sponsored, you must be a member of a political party and be sponsored by a political party. So the argument that will be posed by neutrals like me, who is not involved in the case in the PEPT, is this: is Section 77, subsection 2 and 3, which talks about register of members and 30 days of submission of names of registers of members to INEC, superior to Section 131 1C of the Constitution. The Constitution says that the qualifying ground, the qualifying criterion, among other criteria for you to become president of Nigeria is that you must be a member of a political party and you must be sponsored by a political party. The question here is this: if you look at the way Section 131 is couched, it is not couched in the context of time. So it is not framed by time. So I think that looking at the argument posed by APC, it's not supported by the Constitution. The Constitution does not say that, you must be a member of a political party 30 days before the register of members is submitted to INEC. That's at that level.
Okay.
And case law here will mean that decisions, racial principles decided by courts around issues also guide our understanding of the issues. In respect of Section 131 and Section 77 of the Electoral Act, the Court of Appeal is a recent 22-23 decision involving Allied People's Movement against Peter Obi, decided that you cannot contract the grounds for qualification for president of Nigeria by using Section 77, subsection 2 and 3 of the Electoral Act. The only qualifying ground is that specified in subsection 1C. Are you a member of a political party? If the answer is yes, you can contest. Are you sponsored by a political party? If the answer is yes, you can run. So on the basis of the decision of the Court of Appeal, and interestingly, it is the Court of Appeal that will sit as the Presidential Election Petition Tribunal. So that aspect of the respondent reply of APC has already been knocked out by a decision, by the current decision of the Court of Appeal. Interestingly, the lead judgment of the APF against Obi and others, was read by the president of the Court of Appeal, who will be sitting, as part of the PEPT.
Can I understand the last? You said who will be sitting as what?
Yeah,
as part of
sitting as part of the panel, because you see,
okay, the presidential election panel
by law to panel those who will hear the election petition tribunal as the PEPT. So the interesting thing, the judgment I refer to now, the lead judgment was read by the justice, who is a woman, who will be impaneling 6 other judges who will sit on the presidential election election. So over to you.
Thank you so much. Can you hear me? Yeah, I can hear you. I can hear you. So thank you so much for your explanation. It really brings everything together. So on this issue, just for me to ask a question, did Obi participate, did Mr. Peter Obi participate in the primaries of Labour Party? Or was he someone that resigned and he took over?
No, I think a lot of Nigerians did not follow the brouhaha that happened. I followed it closely. Look, when Obi left the PDP May 26th and joined the Labour Party the following day, 27th of May, the presidential primaries of the Labour Party took place on the 30th in an hotel in Asaba. Don't forget that there were 2 other aspirants within the Labour Party. Professor Patu Tomi, who was an aspirant, withdrew and supported Obi. The presidential primaries of the Labour Party was between Obi and a lady whose name I have forgotten, who insisted that the democratic process must take its course.
Yes.
And she lost. She lost Obi. So Obi actually took part in the Labour Party presidential primaries.
Oh, okay. So he did take part in that whole issue. So all of this issue of whether he was still a member of PDP or he did not reach there on time, his name wasn't on the register. So
the point is this: Labour Party is not saying that as at May 30th, 2022, Obi was a member of the Labour Party. Their contention is this on the basis of Section 77, subsection 2 of the Electoral Act. The Electoral Act mandated, empowered, it was compulsory, the Labour Party to submit its register of members to INEC, within 30 days. The 30 days elapsed on April 30th, 2022. As at April 30th, 2022, Obi was still a member of the People's Democratic Party. So the argument of the APC and Bat's lawyers is that, when Obi took part in the Labour primaries of 30th May 2022, his name was not in the register of members of Labour Party. So by virtue of Section 77, 2 and 3, Obi would not have been the lawful and legal candidate of the Labour Party, because by the mere fact that his name was not in the register of members, as at April 30th, 2022, he was not a member of the Labour Party. That is the contention of lawyers of BAT and the APC. But the point I'm making, on the basis of the Court of Appeal decision, is a recent decision, 2023 decision, that we cannot contract the criteria or criterion for qualification for the presidency, as stated in section 131C of the Constitution. The Constitution says you must be a member of a political party, and that political party must have sponsored you, The issue of register of member is not a qualification for becoming president of Nigeria. That's the decision of the Court of Appeal. In Allied People's Movement versus Obi and Labour Party and another.
That's quite great to hear. Thank you so much, the great Oracle. Even though you say you are Abdul Mahmoud Esquire, on YouTube, all of them are just like the great Oracle from the sanctuary. So as I'm flowing,
the Sanctus Sanctorum.
Forgive me if I keep going there, because that's what they're really talking about. So apologies for those of us who are watching. Mr. Barrister, why did I even say Mr.? So I'm a bit confused now. Barrister Inibehe might not be joining us. He has a bit of an emergency he has to tackle with that has to do with one of his clients. And then he did say he will try and join, but I've said to him, please, it's okay. Let him go on and deal with those issues. You know, this election petition issue, they are very time sensitive. So he needs all the attention he needs to put in there. So we might not be seeing him today. And also there was a bit of mix up where a link that was sent in, today's link, I sent in the last week's link to some of this out there. So apologies for that also. I'm trying to send in the right link for this particular program. Dudu, please, if you can unmute yourself. Are there questions from YouTube that you can give us now? Because I'm just trying to do quite a bit of some other things. And also for those who are listening, if you can drop some of your questions right now, we'll go ahead in the chat and read them. Let's check. And yes, you can send in your messages through chat. It's been quite educating and quite interesting listening to Abdul Mahmoud Esquire. Really on this particular issue. What is it about this? Can you give us more on this issue of burden of proof, where we have who is the burden of proof on in terms of, hello, can you hear me?
Yeah, I can hear you.
Yeah,
I switch off my video because the network is playing out.
Oh, okay then. Yeah. On this issue of the burden of proof, can you just give us a bit more, throw more light on that? Who is it on? Is it on the petitioner or on the respondent?
We have to refer back to the general burden of proof as we know it in our legal jurisprudence. What I mean here is this: whoever is asserting has the burden of proof on him. If I say that Aisha is not a married woman, she's a single parent, against known facts, the burden of proof that Aisha is a single parent is on me, because I'm the one asserting. So in the context of the petition before the tribunal, some of those issues around qualifications that Obis lawyers had raised in their petition before the tribunal, the burden of proof is on Obi, because he's the one asserting. Take for example the question of double nomination of Shettima against Section 35 of the Electoral Act. Obi is saying that as at 14th of July 2022, when Shettima was nominated as a vice presidential candidate on a joint ticket with BAT, he was still a senatorial candidate of the APC in Borno Central Senatorial District. And Obis lawyers are relying on a letter. And the burden of proof is on Obis lawyer to assert the fact that there was actually double nomination as at 14th of July 2022. And if you look at the petition raised by BAT and also the respondent's reply raised by BAT and also the APC, Inebe is here now, I've just admitted it. You will see that you will see that APC has rebutted that his Obis petition is founded on. Therefore, we formally withdrew the candidacy of Shettima in a letter to INEC. Why the letter on its face of it bore 6th of July? The internal minute of INEC, bore 14th of July. I'm a lawyer. I don't want to raise strenuous issues. It beggars belief that a letter was written on the 6th, submitted to INEC on the 6th, and 8 days later, there will be questions around the authenticity of the date stamp on that document. I'm very sure about it. I'm a practicing lawyer. I know what goes on in the registry of courts, in offices, in our country. So to answer your question straightforward, the burden of proof is on Obi because he's the one asserting. But the interesting thing about election petitions as well, election petitions generally is, if you are also raising, criminality, rigging, issues around crime, the bar of proof, is no longer on the basis of balance or probability. Is on the basis of beyond all reasonable doubt. So if you look at the respondent's reply, you will see the consistent use of the phrase, we will put them to the strictest proof, virtually in all grounds of the respondent's reply. So over to you, Aisha.
Thank you so much for that explanation. We have with us right now Barrister Inibehe Effiong, although he too say he just prefers to be called simply Mr. Inibehe Effiong. Hello, Barrister, can you hear us? Kindly unmute yourself. You can do that. You are also a co-host.
Yeah,
okay.
I can. I
okay,
can hear you.
Fantastic. Well done. I had earlier given apologies and I even told them that you probably will not be joining us because I did send you a message. I say just concentrate on the thing that came up that you need to focus on. But of course, knowing this is what we talk about, integrity, being consistent, and people doing, when they put their words that they're going to do something, they make sure they do it. This is what it is all about. So I'm really happy that you're taking time out to join us now. Thank you and welcome. We're looking at the respondents' brief, and go ahead and give us what's your overview on it all. We also have with us today the great oracle himself, Abdul Mahmoud Esquire, joining us. He has been giving us, he has started with his own overview. We'll be talking about it. So welcome and join us, and let's also have your overview. In the meantime, we'll also have questions coming in from our listeners and also our viewers, and I will pass those ones on to you.
Yeah, again, I apologize. I had planned to be part of this engagement from 6. However, I have a client who is participating in the House of Reps supplementary election, and some issues have arisen in the course of the process today, for which my response was required, which I had to respond to. And then, quite regrettably, I have quite a limited time because I had also coincidentally accepted another engagement from 7. So I had thought I could spend an hour today. I don't know how I'll be able to navigate that. But just quite briefly, and again, I welcome the great oracle. I sadly I could not listen to your interventions, but I trust that they are quite robust as usual. I have examined the issue.
Hello, Enibe, we can't hear
that
you.
has been written
Okay.
from the respondents and then the APC. Yeah, that have been filed by Tinubu and the APC. Some of the points they have raised are strong. The fact that a point is strong does not necessarily mean that it will succeed in court. It is just that they are germane. They are not objections or issues that you can just dismiss by a wave of the hand. Some of them are just basically activated to distract the petitioners and also create some sort of credibility crisis for the election petition, even though I do not see how those objections can fly. For example, the issue regarding Obis alleged belated membership of the Labour Party. I don't see how that is even a matter for them to bother is a second on. I don't see how that can be countenanced at the tribunal. I will want to see how the Court of Appeal will respond to them. But my assessment is that that is basically done to distract the petitioners. One, because the issue of membership of a political party, the Supreme Court has said repeatedly, it is internal affairs of the party, right? It is not the business of outsiders or non-party members to complain about it. And even where there should be a legitimate complaint arising from any provisions of the party constitution, INEC guidelines, the Electoral Act, or the Constitution, such complaints must be brought within the purview of a pre-election matter, which must be filed within 14 days. Again, that can only be done by an aspirant who participated in the primary that to be contested in and became the candidate of the Labour Party. It is not something that can be activated by outsiders or people who have no stake in the matter. So I see that as a distraction. In any event, the provision of the Electoral Act that they have cited does not support the argument, because it says that a party shall submit the list of its members to INEC 30 days before primaries or congresses. It does not say that after that time, the party can no longer admit new members, or that the new members will not be eligible to contest in the primary to become the candidate of the party. It does not foreclose that right. What the Constitution says is that one should be a member of the party and be sponsored by that party. And it is the party that determines sponsorship. So I don't see how this is the business. One, APC doesn't have the locus. Tinubu doesn't have the locus to argue on that. And even on the merit, for me, the argument is a non-starter, really. It is a non-starter because what is the issue? What is the complaint about? That is not a member of the Labour Party. Are you the one to complain about that? So I don't see how that is a problem. And political parties, even if we are to look at the merit of the argument, parties have the right to grant waiver to anybody to contest on their platform. You don't need to be a member of that party for any definite period. The party can grant waiver. So if the party says, this is our candidate, this is our member, and you said no, because your name is not in the register that was submitted 30 days before primary, you cannot be the candidate of the party. That is stretching the argument beyond what the law can, what is legally permissible. So that is about that.
Okay.
The other issue about not joining Atiku, I think that is just not joining Atiku in the Obi petition, and they have also made the same argument against Atiku that they did not join Obi. I think that is another, interesting argument, but I don't see how that really matters, really, because INEC is the one that conducts election. And the areas where votes have been where the petitioners have made complaints regarding the votes that were recorded, right? The law does not say that in a state, for example, I read where Tinubu is complaining that why it will be complaining about results in states that he did not win. The law does not say that the petitioner should concentrate on states that the man or the person candidate returned elected won. No. Any state where you believe that what you should have been due to you in terms of votes was not given to you, recorded for you, you have the right to challenge it. Otherwise, the implication will be that a petitioner has to join all the presidential candidates and political parties. You cannot make a special exception for Atiku, and you don't make it for the AAC, you don't make it for the other political parties. Therefore, all parties, all the 18 parties, all the parties that had candidates must be made parties to an election petition. That will make nonsense of the entire process, because those parties also recorded votes. The law does not say that you should challenge votes from a state on percentage basis. I don't know if you get me.
Yeah.
So it is not a question of saying, oh, Atiku won in this state. Why am I being challenged in those states? No, that is not the basis. That is not the basis. And recall that in our previous engagement, I took time to explain the disparity in law between lawful votes and majority of lawful votes. One can have a majority of votes, but those votes may not necessarily be lawful votes. So these are the issues. I see that those objections on those two grounds as just very distracting. I don't see how those ones are going to fly. The one that is a bit strong is the one regarding the allegation of drugs or Tinubu's indictment in the US. Again, that is going to depend on the attitude of our courts, how the court is going to perceive the issue. But they have made some strong arguments, that some germane arguments. One, of course, they have raised the issue of time. I'm not really sure that applies given the provision of the Constitution under which the disqualification argument is founded on.
Mm-hmm.
I'm not sure that issue of the time will really fly. But they have said, the Tinubu and the APC have raised some issues on why that should not be used against them, that the forfeiture is not a fine, it is not this, it is not that. Some very interesting technical argument that they have made. They have also said, the issue was previously litigated. I haven't seen the judgment of the Federal High Court where that issue was litigated, because the question would be, was it litigated on the merit?
Inibe, what about the issue of the AIT issue? Is that part of what they're talking about? When that accusation had come in and then they went to court and...
that is why I'm saying that...
Case.
No, that is why if I don't think is that one. The one they have referenced, I think is the 1990-something judgment, 1999 or 2000. I haven't seen it. I don't know what the facts were, what the issues for determination were, or the outward decision of the court. But let them produce the judgment, and we are going to look at it and see whether the judgment was on the merit, and whether it was raised as the basis to disqualify him. Because those are two different things entirely. Some of these judgment people are parroting are cases that were determined on technicalities that did not really come before a court of proper jurisdiction, that even the local standard of the plaintiffs were successfully challenged. They were not raised in an election petition as the ground to disqualify, Tinubu or Asiwaju. I haven't seen that. So let them produce that. Let them produce that and we'll look at it. The argument that, the judgment was not registered in Nigeria, I don't know what all that amounts to.
Okay.
Really, okay. I don't know what all that amounts to. That this is civil, the forfeiture is civil, it is not criminal and all that. These are all technical arguments that lawyers have made. I want to see how the court. I have an open mind, to that issue. I want to see how the court, will examine that. They have also raised the issue of particularity regarding that. That is on the aspect of non-compliance. That the aspect of the petitions will be complained about some issues, that there was no particularity in terms of the polling units that were actually affected. Again, that is also a German issue, right? But you must also understand that Obi had constraints in filing his petition because he did not have results of many of the areas that he had sought to challenge, right? So that is also one of the challenges that the petitioners face. Ordinarily, the way you do election petition is that you particularize the polling units. If you are saying that results were not uploaded on the IREV, you have to particularize it. And finally, let me even touch on the issue of IREV. I'm still waiting for a copy of the INEC response. I haven't seen their reply yet. I've only seen snippets of reports in the media, which I find very diabolical, the argument that they are canvassing at the Court of Appeal. It is extremely diabolical. And very insidious that a commission that is supposed to be rooted in integrity is trying to create very, very provocative prevarications by distracting people from what is really the issue and manufacturing an argument for themselves and responding to themselves. There has never been a debate whether the collation should have been electronic or not. So for them to say that the Electoral Act does not provide for electronic collation. Who is arguing about electronic collation? What we are saying is that transfer or transmission of results under the Electoral Act, Section 60(5), Section 64 and others, is a distinct procedure, is a distinct process requirement under the law. It is separable from the issue of collation. Even though it is connected, even though it is related, but it is distinct. It is distinct. All this, I explained last time, the election is a process, and these processes are interrelated. But for INEC to now seek to confuse Nigerians, to make it look like the whole argument about IREF or transfer of results was about electronic, was about collation of results, it's just very silly to me. I mean, to put it very nicely. I don't see how that makes sense. I don't see how that makes sense at all. I want them to explain in court what transfer of results is and at what point that transfer ought to have taken place and who has the responsibility to effect that transfer. Because when you begin to argue about collation, collation is done by collation officers. It's done by collation officers. The presiding officer's duty ends at the polling unit, except that he has to take the results to the registration area, which is the ward level for, the ward collation center or the registration area. But once that result is submitted, his duty has finished. Once he has appended his signature to the result, at the polling unit, that is where he ought to have done the transfer and upload. So for them to now make it look like the whole argument about IREF, about electronic transmission or transfer or whatever is about collation, and they say, oh, it is manual collation that is recognized under the law. INEC is just trying to confuse the court and the public. That is how I see it. And I hope the petitioners will very clinically and distinctly distill this attempt at prevarication that INEC is indulging in.
Okay. Okay, thank you so much, Mr. Enibehe. Coming back to you, Abdul Mahmoud Esquire, there's a question that someone is asking from YouTube. We have a good number of our viewers are on YouTube, and he says that they are raising, there's an issue being raised. I don't know whether it's in that brief that the, what do you call it now, the forfeiture, it's not against the person, but rather against the account.
What is the account?
How does that work? Well, that's
and let us see the accounts now. What is the account?
It is an interesting argument. But let me begin in an attempt to answer this question. I also attempt to give some clarifications to some of the issues that my colleague Iribe has raised. More particularly as it relates to joinder of parties. We're talking in the context of case laws in Nigeria. We talk about proper parties, desirable parties, and necessary parties. Recourse can only be made to the reliefs sought by a party to an action for the court to determine if there is a desirable or proper or necessary party before it. I find the argument of the APC and BAT lawyers rather intriguingly strange, because the necessary party before the court in the petition as put out by Obis lawyer are APC, BAT, and INEC, and the reliefs that Obi is seeking is against these three respondents, not against Atiku. So the argument posed by BAT lawyers are against the weight of case law. And two, perhaps anybody has not read the recent judgment of this same Court of Appeal on APM versus Obi, where the Court of Appeal, per the presiding judge, Justice of the Court of Appeal, held that on the issue of qualification for the office of the president, recourse can only be made to Section 131 of the Constitution, or the disqualifying grounds as specified in Section 137 of the Constitution. The question of whether a member's name is on the list of register of members is not a qualifying ground as stated in section 13 or 131. I think the argument of the lawyers of that here is against the weight of case law. For me, these election petitions will be determined solely by, like Inebe rightly raised, by the disqualifying grounds under section 137, 1D and 1E of the Constitution. Bat's lawyer made a heavy weather in the argument around whether there's a distinction or not between forfeiture or fine. Whether a limiting time bar exists under subsection 1E of section 137 of the Constitution. Like I've always argued, perhaps because I'm not sure section 137 has been interpreted by our courts. Perhaps we may have to go to the Indian Supreme Court and look at the pregnant distilleries case, where the Indian Supreme Court held that, where semicolons and conjunctions and disjunctions are used, they form internal aids for interpretation of the statute. So in interpreting section 137, the Court of Appeal and perhaps the Supreme Court, when the matter goes upstairs, will have to look at how semicolon is used, how conjunction is used by the makers of the Constitution. The argument that there must be a limiting time date or time bar to the question of fine is neither here nor there. Mm-hmm. My argument is that subsection 1E of 137 stands alone from those disqualifying grounds stated in section 137 1D. And the question my friend raised on YouTube is an interesting question. And we do hope that the court will look at the issues before it, distill them, and come out with a judgment that meets with the expectations of Nigerians. Nigerians are holding bated breath, and we're looking up to our courts. Thank you.
Thank you so much for that. In the chat group, Mr. Enibehe just said he had to run to the other commitment that he has. We thank him so much for joining us today, for still finding the time to join us amidst all the things that have happened. Please, if anyone here on Zoom would like to ask any question, kindly go ahead and raise up your hands. In the meantime, we have quite a number of questions that are really coming in from the YouTube viewers. Dudu, can you please unmute yourself and give us some of the questions from there? Hello, Dudu, can you hear me?
Yes, I can hear you.
Okay, go ahead. Okay, why?
So Godson Emmy. Mm-hmm. Godson Emmy asked on YouTube that, please, is it true that the Chicago court lacks jurisdiction in Nigeria? Hence, the Chicago drug case of BAT would not be considered?
Okay, thank you so much. Abdul Mahmoud Esquire.
I don't have the Constitution here, but extemporaneously I can refer to
is there a particular place you want us to check?
Yeah,
I can read
yes, look at section 1371D and just read it out for me. It talks about death sentence or conviction imposed by a court or a tribunal, and goes ahead to talk about fine for the offense of dishonesty. Each disqualifying ground separated by the conjunction or. But when you are going to the end of section 1371D, where it talks about
let me read it out.
Just read it out.
So we have section 137 says a person shall not be qualified for the election to the office of the president if, and that D says he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. Then it says or, and there's E. Should I read the E?
Yes, let's stop there. Just stop.
Okay.
Before you get to the terminating point of subsection 1D, it talks about fine for any offense imposed by any court. Any court. The phrase "any court" was used twice. First, in respect of conviction and sentence, death sentence imposed by a court in Nigeria. That subsection 1D was specific. Sentence for death imposed by any court or tribunal in Nigeria. When you are going to the terminal point of subsection 1D, it talks about, for fine, any offense is omnibus. It does not specifically mention the offense. It relates to every offense that relates to dishonesty. It could be 419. If you look at section 4110 to 433 of the criminal code, I don't have my CC here. It specifically states out, offenses that relates to dishonesty. But the Constitution says for any offense imposed by any court. It could be any court in Yugoslavia, or in Slovakia, or in England, or the United States. So the whole argument of the APC lawyer is unfounded on the basis of section 1371D. What they have done here is to lump the entire disqualifying offenses stated in subsection 1D together. My argument is that they are separated by the conjunction or, and also by semicolon, semicolon. And Inibe also highlighted a point, which they raised, that in any term, even where we concede and we are not admitting, the judgment civil forfeiture order that was made by the Chicago court was not registered in Nigeria. That argument is also unfounded if we travel to a small piece of legislation called Foreign Judgment, Reciprocal Enforcement Act of 1961. If you look at subsection 4, subsection 1 of that act that I refer to, it says that where the order or judgment has been wholly satisfied, the order of the Chicago court has been long wholly satisfied. Money were forfeited from Bat's account. So the judgment or order need not be registered in Nigeria. But don't forget, the civil forfeiture proceedings in United States arose from a crime. My contention is that the order of the Chicago court is a criminal order. We need not have it registered in Nigeria. And that's why I disagree with the lawyers of BAT.
Thank you so much for that. We have sources, Adeyanju, that has raised a hand. So I'm a bit listening. I don't know whether it's male or female. So that's why I can't say he or she. But sources, go ahead, please. Kindly unmute yourself and go ahead with your question. Hello, sources. You're still muted. Can you unmute yourself, please? Okay, while we're waiting for sources, okay. Okay, go ahead.
Right. All right, he's a male. I'm a male.
Male.
All right. So my question is this: at what stage do we think forensic investigators will come into this issue of IRF? And if this will come up, who is going to be the driver? Is he the Labour Party that will be the driver, that will be the one to initiate it, or the court? That's my question, please.
Thank you so much. I think Mahmoud Esquire just explained to us that the burden of proof It's actually on the petitioners themselves and not the respondents. But let me hand over to you. Let's hear from the horse's mouth.
Well, I do not think that Obi's lawyers will go to the extent of placing a subpoena on the court officials of the South Illinois Court in Chicago to give some testimony or testimonies to the Presidential Election Petition Tribunal. We are dealing with documentary evidence here. Obis lawyers have uploaded the decisions and judgment of the Chicago court. Nobody is denying the authenticity of the document itself. Where oral testimony will have to be adduced will arise where there are arguments around the authenticity of the document, or where conflict exists between the arguments of Obis lawyers and those of bad lawyers. I think within the realm of election petition, don't forget that election petitions are generally sui generis, and they are time barred. We are dealing with 180 days. 180 days started counting, some few weeks ago. Bringing foreign expert to give testimonies for me will be time consuming, if not time wasted. But bad lawyers are challenging the government of these arguments, and they are, of course, posing judgments which Inebe earlier referred to. Judgments as relates to the question of qualification of Bat as governor of Lagos State in 1999. And they are also relying on the letter written by a legal attaché of the United States Embassy to the then Inspector General of Police, when this whole issue of Bat's connection to drug trade in the United States was raised in 2001, 2003, or thereabout. So these are documents, legal documents, recognized by Section 87 and 88 of the Evidence Act. They become public documents. The court will have to take some judicial view of these documents. I hope I've answered the question. Success, by the way.
Success question. You didn't answer the success question. Success question is on IREF and forensic investigator.
Oh, IREF, yeah. Oh, okay. Sorry, Success. I misconstrued your question.
Yes, he's directly on the IREF.
Look, I think we have to go back to the decision of the Court of Appeal in respect of Adeleke and Uyotola. We'll be dealing with three issues here, rolled into what exists as primary source, what exists as secondary source, what exists as synchronization. These were issues that were dealt by the Court of Appeal in Adeleke's case. The information uploaded by INEC officials through beavers, to IREC remains the primary source or result of an election. The results that were received at the back end, which we refer to as IREF, is described as the secondary source. So yes, forensic expert can be called them where there is no match of authenticity between the primary source result and the secondary source result. And perhaps if synchronization arises, and I do think it will, as we are going through the case at the PEPT. For some of you that have been following the uploaded result, we know that over 4,000 PU results have not been uploaded almost 50 days after the presidential elections. I do know that INEC will come out at some point and say that, some of the results that you have are not the authentic results because they have not been finally synchronized by the results we have at the back end. Yes, forensic examination will be key in the course of distilling some of the issues that have not been placed before the Presidential Election Petition Tribunal.
Okay, thank you so much for that. Dudu, can we have some more questions from YouTube before we take Francis?
Okay. So Ephraim Excel on YouTube is asking that what is the grounds for the disqualification of APC's VP elect? And then can we take a second one?
Yes, please.
Fashuyi Miracle also asked, what is the process of admission of electronic copies of polling unit results? He says if INEC fails to provide certified true copies, can the court accept copies of polling sheets as secondary evidence of public documents?
Thank you so much, Lulu.
Well, thank you. Let me deal with the first. I dealt with the first earlier on when I said that Obi raised the issue of qualification or disqualification, if you like, of the vice presidential candidate.
There's a bit of issue with network.
APC on the Brand Act. Section 30.
Yeah, we can hear you now. There was a bit of issue with the network.
Right. Obi raised the issue of qualification or disqualification, if you like, of Alhaji Shettima on the basis of Section 35 of the Electoral Act. Section 35 deals with the question of double nomination, that you cannot place yourself, you cannot allow yourself to be doubly nominated as a candidate of two political parties, something along that line, or in two constituencies. But lawyers have reported the claim of Obi, because Obi's argument is basically founded on the fact that Shettima was nominated as a vice presidential candidate on the 14th of July 2022, and he resigned. He withdrew his nomination as a senatorial candidate of Borno Central Senatorial District on the 25th. 24 hours between 24th and 25th, he was a double nominee for the office of the vice president and also a senatorial candidate of the Borno Senatorial District. Bat's lawyers have also put in the public space through their PO's preliminary objection and respondent reply that on the 6th of July 2022, when the placeholder, what's his name now, Somthi Kiari, was withdrawn and his name replaced with Shettima, they were within the time frame allowed by law. But I also raised question on the face of the document. That letter was dated 6th of July 2022, and there's somewhere where it was minuted on the face of it on the 14th of July. I'm not the opinion on integrity of anybody, but the beggars believe that a document that was signed on the 6th was actioned on the 14th. These material conflicts will have to be dealt with by the Court of Appeal in the course of hearing the petitions and the respondent reply. On the question of certification of documents, the Court of Appeal will rely on the CTC document, provided for it, by the parties. It's on the basis of that. If you look at both petitions of Alhaji Atiku and of Peter Obi, all the documents that have been front-loaded are CTC documents, and the documents that have also been front-loaded by Tinubu's lawyers are also CTC documents. But don't also forget that on the decision of the Court of Appeal, I was involved in that case, Judge Sekibo against the APC. The Court of Appeal strangely held that the duplicate pink copy of result sheets that from EC8A that are usually in the custody of the police can also be relied on by the courts, So you are right. The court will reply. Look, ordinary result sheets flying all over the place on electronic apps do not meet the test of the Evidence Act. They are not certified true copies of of the result. Those result sheets cannot be tendered.
Okay. I think the last time we had this conversation, that was also what Barrister Nibehe had said. Those results cannot be used. We'll now come back to those on Zoom here with us and start with Francis. Francis, go ahead and unmute yourself and let's have your question. Please keep it within 2 minutes, either your question or your comments. Francis, can you hear me? Are you? Yeah, go ahead, Francis.
All right. Good evening. Good evening, everyone. Good evening, Gloria, Mahmoud. And thanks, Sister Aisha, for this nice program. I just wanted to find, I don't know if he has addressed it, but just to ask, what is his view on the 25% of FCT, the role of 25%, the role it plays, and what is his view on that 25% that has to be scored in FCT? Okay. So I just wanted to hear you. Thank you very much.
Thank you so much for that. Francis, I think we'll move to Eze Peter. Can you give us your, can we have your question or your comment, please? Go ahead and unmute yourself.
All right, good evening, everybody.
Good evening.
Yeah, my name is Eze Peter, and I just want to ask my own question in this form. The alterations that exist on some of the resource sheets, because I actually served as a coordinator of polling agents in one of the local governments. So, and when the resource sheets are being collected, we understand that there are alterations on the resource sheets, like cancellations, like using T-Pest to alter result sheets. And then I am asking, what is the loss stand, especially when the alteration is not countersigned? What is the loss stand on this kind of alterations? Thank you.
Okay, thank you so much. We'll take the hands raising, that then we'll come to our guests to answer those questions. Abraham, can you please unmute yourself?
Hello, Aisha. Hello, Mahmoud, and hello, Barrister. I don't the third gentleman. Yeah, Mr. Barrister Nibehe. It's a pleasure to talk to you as always, Aisha. You're doing the Lord's work, as I often tell you. You're doing the Lord's work. I'm gonna be brief with my question. To the two barristers in the house, I have two questions. What is it? Because to be honest, it's not the first, second, third, or fourth time somebody with a criminal history and a proven criminal background will occupy exalted position in our country. I mean, from the top of my head, Omar Gege, Femi Gbadabiamole, Sanwo-Olu, Dapo Abiodun, all these people have checkered past and criminal history and criminal record. Why is it that nobody, before they get to these positions, nobody actually like test the law and test this constitution that says if you have a criminal record, you should not hold an exalted position in our country? And my second question is very simple. I'm not a lawyer, but haven't read through the response of the All Progressive Party. I actually put their response in the AI, and I found very, very numerous contradictions, double speak. I don't understand. Like from that document, what's your assessment if you give it a score of the response? To me, that response was a D minus, something that looks like it should have been written by a second or first year law student. That does not inspire me. Like SCNs put their name to that. I'm sorry, but that's a laughable document for a response. I'm trying to get your grade on it because there are so many contradictions there. It's funny. Thank you very much.
Thank you so much. I'm going to take the final one before we go back to our guests to answer, and that's success. You've spoken before, and that's why I kept. So I know I lower your hand, so I know this is a new hand being raised. So go ahead, please. Let's hear what is it. What comment or question do you have?
Okay, thank you very much. This is not success, although we are like a family here
Oh,
listening
okay.
to the whole conversation.
Oh,
We
this is
are
a
more
new
than,
person. Apologies.
yes,
I'm
my
so
name is
sorry.
my name is Dr. Peter Ebuatu.
Okay.
We are
No,
just
so let
circled
me
around.
understand. But you're using sources. You're
Yes.
using the same
Yes,
device.
I'm using
Ah.
Success Phone. We are just like
Okay.
about 10 of us listening through Success Phone.
Okay. Okay. Go ahead then.
So it's like a family thing.
Okay.
Now, Dr. Peter Ebuatu is asking a question. The question is simple. Why is it taking our legal system up to now to even address any of the issues raised in the petition? Why would it take this long when someone as highly placed as Olisa Bakoba has stated that it can just be resolved within 7 days? But here we are speaking and talking grammar, and then time is passing. And before you know it, they'll start labeling somebody that you are committed treason because you don't want anything to happen that is unconstitutional. Why is it taking this long? Can't we get it done in a jiffy? And then if those that we can resolve immediately, we resolve them. Those that needs evidences to prove, that one can be waiting. But the ones that can be resolved now, like issues that has to do with the constitution, can be resolved in a question of 2-3 days. Olisa Abakoba spoke so much about it. That's the question I want to ask.
Thank you so much. So we will go to our guest now. And
Aisha, I have had a bundle set of.
I have them written down, so I can always start from.
Let me start with the first, in respect of
Francis, right?
In respect of the geographical distribution of votes around 25% of 36 states, and the argument has always been
Mr. Mahmoud, your network is acting up. Oh, it's really bad now. We can't hear you. Hello, can you hear us? We can't hear you. No, that is. Hello? No, it's really bad. Dudu, please, can you reach out to Mr. Mahmoud and tell him we can't hear him? His network is really bad.
Yes, I'm trying to do that.
Yeah, I'm trying to mute him. I don't even know why I can't mute him so that we can get. No, it's really bad. I can't even see him again. Has he dropped off? Yeah, I think he has dropped off. So we'll try from the back end to reach out to him and get him to come back again. But while we're waiting for Mr. Mahmoud to come back in, I think I would just take a bit of the last question that was asked by Dr. Peter. Initially, so I was actually right because I knew that Success had asked the question before. That was why I made him, though he wasn't the last. I made him last because he had the privilege of asking that question before, although later to find out that it's a completely different person that was asking a new question. The question that Mr. Peter had asked was, why is it taking this long for the courts to do what they need to do for the judiciary to act? And I think the simple answer from my own end of the wheel, I'm just a lay person, like the lawyers will always say, I'm not a lawyer, is to say that it's because the law allows it. So there is a timing within the law. So we have that 180 days that we that is there, and so they have to use that. In as much as we keep talking, like I see a lot of people who are getting frustrated and always saying, "Okay, why are we just talking? Why are we just doing this? Can't this thing be done?" You have to follow the law. I see, and whatever we do, we must do it from within the ambit of the law. Because if you do anything outside the ambit of the law, then there's no difference between you and the people that you want to. We are calling now, we want them to step aside. And so that's the thing. That's the thing about being disciplined and doing things. It can be very, very frustrating where you see certain things that, for example, on the issue of whether 25%, yeah, that can be decided to say, okay, the result, you did not qualify. So instead of waiting till May 29 to begin to swear somebody in, you just, okay, go back to the polls, go and redo the election, or check this result, arrange them again and let people have their legal votes. But the court has given, because the law says this is the number of days it is within their own right to take that number of days. They don't have to hurry. They don't have to do it earlier. So we must understand that. That now comes to the question where it is that is where is the bedrock of the democracy, and that's the legislative arm. So if we really want laws to be changed, for things to work the way we should focus on that legislative and ensure that they're giving us laws that we apply to situations like this and really be there for the country. For example, there is a whole lot of need for us to have a new electoral act. Yes, we've just had a new one. We need another new. And these are some of the things that should be part of the law in that electoral act, to say that all petitions must be resolved before the swearing in date. And maybe give a bit of time so that there is time, and then if they need to go and conduct fresh election or whatever it is that need to be conducted, let that be done, so that you don't have situation whereby you are swearing somebody in who is not legally supposed to be in that place, and then you now come and then there's a judgment and the person is going out and you are having to rechange the thing and all of that. So it's very important. So that means that we have to be focused on the people that we are sending to the National Assembly, the people that we are sending to the state houses of assembly, and we must focus on the legislative arm. And wherever there's election of people by elections, so right now there's a supplementary election. A lot of people are not focused on it. We can't just be focusing on the executive election, governor, president. No, the legislative arm, senators, House of Rep members, House of Assembly members, the councillors, they are very, very important, and we need to put that attention on them. So we have Abdul Mahmoud is here with us now. Okay, go ahead. Welcome.
I'm sorry, Aisha, for the breaking translation.
No,
in respect of the geographical distribution of votes as it relates to 25% of the C states and the FCT, as specified in the Constitution, the arguments around it are not new.
Mr. Mam, can you please start your video so that we can spotlight you and bring you in here? Even if you need to off it later again, even if you start, I think I need to have that video on to be able to bring you to the center.
Where I am is very dark.
Okay, no problem. Go ahead there, no problem. It's okay. No, it's okay.
The arguments around 25%, the arguments aren't new. Olisa centered the argument prior to the 25th of February elections in his letter to INEC. Unfortunately, INEC did not address it. But we must stay within the ambit of the Constitution. What does the conjunction "and" mean? Does it mean that there's a certain level of superlative criteria, created for the FCT as against 24 states, which constitute 25% of that C states?
Hello.
These are arguments that the Supreme Court will have to. We must go back to the 1979 imbroglio or saga around this same particular issue and ask ourselves, what was the mischief the makers of our Constitution tried to create when they inserted this provision in the 1989 Constitution? 1989 Constitution was a stillbirth constitution. It did not come into operation because IBB, as Maradonic as he was, during his years in power, started playing Nigerian politics like a piece of football, And it's that provision that was further taken into the 1999 Constitution. We've not had a test of it because presidential candidates that we have had between 1999 until 2019 scored 5% in FCT, so it wasn't. The Court of Appeal looks at what "and" means in that provision or section of our Constitution. But one external aid that will help the Court of Appeal coming to its decision is to look at what lawyers call the legislative memories, or legislative memory. What went into the discussion, into the conversation of the National Assembly when that section of the Constitution was drafted. And by looking at the legislative memory, we will have a sense of commitment, a sense of intention or intendment of the drafters of the Constitution. Did they intend to make Abuja a superlative super college that if you do not score 25%, regardless of the number of states that you score 25% in, you cannot become president of Nigeria? I side with those who argue that you must score 25% of 36 states in our country, and also very imperatively score 25% in the FCT. For those who pose the whole argument about Section 299 of the Constitution, which makes FCT a state, the commonsensical question I do pose for them is that if FCT is as assumed by Section 299 of the Constitution as a state governor is expected to score 25% of the number of local governments that make up the state. Can't the president, who now is assumed to be the governor of the FCT, expected to score 25% of the six municipal councils that make up FCT? So the argument of those who say that no, you don't need to score 25% is neither here nor there. That is one. Then at another level, the whole question of criminality of public servants in our country. Yes, Nigerians are not doing much simply because we are also hampered by the ways and manner our laws are drafted. If you want to raise objections, for example, on the issue of qualification of that, the commentary is, are you an aspirant in the primaries in which Omo Agege has taken place? So it does not create that right and privilege for ordinary Nigerians who have this fact within their knowledge to approach the court and say, no, Oga, this man, when one become senator or member of House of Reps or governor or legislator in the State House of Assembly of my state, not thief. They don't catch them for stealing before in the US or in the documents verifying the facts that we are making of our law. If you don't establish some bar, you will be opening up a floodgate where every Tom, Dick, and Harry, meddlesome interloper, busy bodies will be running to court with the most frivolous, allegations against individuals. I think it is for this reason that the law has created some specificity as regards, the requirement for challenging people's, people's qualification for running for offices in our country. Then the third, and I empathize with Nigerians here. The law says, Section 285, I think subsection 4 of the Constitution talks about the period in which election petitions can be heard, 180 days. Nothing stops our courts to conduct and hear proceedings and hearings of election petitions within 7 days of that 180 days. Just look at generally section 285 that deals with election proceedings under the constitution, with specific reference to section 4, 8, 12, and 14. But we do know for sure that in our country, and I'm very sorry to say this because I'm a lawyer, the way power is structured in post-colonial state like ours, power always trumps law, always trumps state institutions. These people who make up our courts, people who make up the institutions that were expected to give judicial decisions, do not really enjoy the independence of the institutions they had, that they run. It's unfortunate. We have seen in our country that by mere allegation, a chief justice of Nigeria was removed from office. And perhaps because power trumps law in our country, power trumps everything that stands in its way, judicial officers are reluctant to exercise those judicial powers that we think are attached to their offices. But nothing stops them. And I agree with Agbakuba. If you look at the issues before the tribunal, the PEPT, the Court of Appeal at the moment, there are issues that touch on the law, the electoral law, and the constitution. What the PET said, look, you have filed your respondent's reply, file your brief of argument, make arguments and but unfortunately, there are other substantial issues that has to be proven. The issue of criminality, the issue of rigging. That cannot happen in 7 days because on the basis of the authority of Buhari and Atiku, the Supreme Court held that when you are raising criminality on election matters, you must prove criminality in each of the polling units across our country. And we are talking of 176,000 polling units. You cannot prove criminality in 176,000 polling units in 180 days. It is impossible. And that's why I think that, we should find a common ground, a compromise ground that will allow us to.
I think the network issue again is,
election petition. Yeah, can you hear me?
Yeah. You went off for a bit, but we can hear you.
Yeah, we can find a common ground, like we did have. A lot of Nigerians don't know. In the 1979 constitutional election cycle, election petitions matters used to be dispensed off with before swearing in took place 1st of October. But unfortunately, this set of politicians, and I think the problem was created by General Abdul Salami in 1999, when they came with this all May 29th swearing in and all that, and they drew up draft of laws, which included section 185 days that created to section 285 of the constitution that created the whole argument around 180 days. And 180 days plus 60 days at the appellate level between Court of Appeal and the Supreme Court will be about 245 days, which is almost 8 months. So we'll have a president-elect who has already been sworn in office, who will be using the instrumentation and instrumentality of power to hoodwink the court on election appeal matters. And that will not augur well for our democracy. So I seriously think that going forward, we should now begin to look at this old business of 180 days and how we can dispense with election matters before swearing in can take place.
Okay. Thank you so much for that. As we go towards rounding up, we have like 17 minutes more to go. There's a question from Eze Peters that you haven't answered, and that's on the issue of alteration of result sheets. What is the stand of the law on all of these results that have been altered, changed, mutilated, and all of that? Some of them actually even are uploaded onto IREV. We can't hear you.
On the face of the face, on the face of this document, I can't really place my hands on the relevant sections of the Evidence Act. Where documents are altered, they are clearly inadmissible. They are clearly inadmissible. I do not think that these altered results are admissible documents. Okay. On the basis, I can't recall the provisions of the Evidence Act. The Evidence Act deals with altered documents.
Okay.
Those documents are clearly on their faces falsified documents.
Okay. And then the second part of Abraham's question, which says, what is your, what did he say something about? What is your assessment of your overall assessment of Bat's brief, Bola Ahmed Tinubu's brief? What do you make of it? You're muted.
Myself, what do I make of it? I think I would take the position of Inibehi. Strong and weaker points have been made by the respondent's reply. I.e., let me deal with the weaker point because it's against the weight of case law. The issue of non-membership of the Labour Party, as at when the register of members was submitted 30th of April 2022 is weak because the Court of Appeal has held that it is the provision of Section 1311C that deals with membership and sponsorship of a candidate by a political party that is the qualifying criteria for election of a president in Nigeria. Whether your name is the electoral membership register of a political party is not a condition set by Section 131. That is clear. Two, on the question of dummy nomination of the vice presidential candidate, if we extrapolate on the principles of law set out by the same Court of Appeal in Allied People's Movement against Obi, that itself is a pre-election matter. Because if you look at Section 285.14, I think 8 and 14 of the Constitution, Section 82. 5.8, it deals of the Electoral Act. 5 is a provision of the Electoral Act. So any conflict arising from Section 35 is a pre-election matter. That knocks off the argument of Obis lawyers. But on the argument on qualification or disqualification, that is the strongest point. And I think the election petition of both sides, of Atiku and of Obi, are founded on Section 137. Is the forfeiture order or conviction imposed by the Chicago court, does it sit within the ambit of Section 1371D of the Constitution? I have consistently argued, even before this whole argument busted the public space, that the disqualifying grounds we find in Section 1371D are 6 disqualifying grounds. And the one on fine does not decategorize fine in the context of civil and criminal fines It says fine as regards dishonesty. It is for the court to now determine if the forfeiture order that was granted by the Chicago court falls within the ambit and the definitional meaning of fine imposed by any court. But if we can painstakingly look at the documents that have already been put in the public space, don't forget that one of the grounds in which the forfeiture order was made was that BAT lied to the FBI agents. Lie, falls within the definitional meaning of dishonesty. And on the basis of the omnibus phrase used there, any offense under Section 1371D, I think Obis lawyer can make a meat of their argument before the Court of Appeal. It's for BAT lawyers to rebut it. They have raised what I think is very strange argument that The judgment of the court in America is not a registered judgment in Nigeria. I've also raised the point that by virtue of Section 4, Subsection 1 of the Foreign Judgment Reciprocal Enforcement Act, is an act under the Law of Federation of Nigeria 2004. It's a 1961 act. Any judgment or order of a competent court that has been wholly satisfied does not need to be registered in Nigeria. So that takes the wind out of the sail of Obis, of bad lawyers as regards that. And the other substance of their argument is this, that Obi did not bring PDP or Atiku as a respondent in his petition against BAD. In effect, they are saying that Atiku is a necessary party, but Obi did not include him. I think that argument, again, with due respect to the senior advocates, some of them my classmates, some of them my juniors at the bar, is misconceived. The question of joinder of parties is founded on the reliefs. Who is Obi seeking relief against?
Yeah.
Atiku did not organize and conduct the 2023 elections. The relief being sought by Obi is against INEC, who conducted the election, and against the declared winner, PDP, APC, and BAT. Thank you.
Thank you so much for that. It's really been interesting. Trying to get some of the questions here that someone has. Pauline is asking about the party itself. I think, like you rightly said, the question that you've asked, they are out of here, but we'll come back, we'll come to them again. I'm trying to get in the link. Last week, we were here with Mr. Barrister Julius Abure, the chairman of the Labour Party, and he did give us sent in certain links for 3 states, which they have now, and they say when the others are ready, they will send them in. Some of the questions, so that's what I'm trying to work on. I'll put that on the link on the chat. Some of the questions that are being raised are coming up on the issue of constitutional reform. Constitutional reform, it's possible, it's done, right? But you do not need, you don't want a situation whereby people who do not care about the country, who only care about themselves, being the ones to review the constitution. When they review it, they will definitely do the things that they want to do. I've seen where someone said, hitherto, candidates were checked, background checks were done on them by INEC, by DSS, and all of that. But the thing is that what we've had is that the laws have been abused by so many people. So we're running for office, and that's what Abdul Mahmoud Esquire did mention, that some people will just bring busybody, anyhow case, just things that are not on the road, just to waste the time of the courts to derail issues. And so that was when that whole thing about candidates was taken out. But if we want laws that really work, we need to, like I will constantly keep saying, we need to focus on the legislative arm of government. We need to have competent people go in there. We need to watch out, little by little, begin to harvest where can we get competent people run into office. For example, maybe in the next 6 months, there's going to be a by-election in Sokoto, and it is for House of Rep. Maybe the results have been tribunal have overturned result, or someone has died, or something has happened. There's by-election. Can we all put our attention on that by-election and ensure that someone with competent character capacity and that is patriotic gets to emerge as winner, even if it's not in our party or anything, but just to help someone with competence that we go there and do the right law, so that in a way we'll populate the National Assembly and the state houses of assembly with people who really care about Nigeria, who are going to make laws, not for their own selfish interests, but for the interest of the country. This is something that we need to do. It's not a marathon. It's not a sprint. It is going to be a marathon, and it may take some years for us to be able to weed off and do it. But it's something that is doable. We saw the Labour Party National Chairman come here last week, and he said to us that out of the 360 members of the National Assembly, that 300 of them are new, are people who are coming in for the first time. Imagine we are doing that by being very deliberate in the kind of people that we send you. So there are so many laws that we need to make, that we need to do, and we need those people. And so we need to pay attention. We've had situations where people get to the National Assembly, become House of Rep members, or even senators with just less than 10,000 votes, because people don't care about election that happen when it is not the presidential election happening. We must begin to care about these things. This is the way we will make that difference and ensure that we have laws. Even the Electoral Act, we need to have it, so many things that we need to have there change. We need to have situation whereby instead of just having the name of parties as logo on ballot papers, we need to have the pictures of the candidates. There are a lot of people who are not educated. They don't know what is Labour Party. Most of us, a lot of people even vote without knowing who are the people in that parties that they are voting for. But if you have somebody's picture, somebody will be able to say, this person is a thief. He stole this, he did that, he's not a good person, especially those who are not literate, not even those who are not literate. People who don't pay attention. You're coming down, you're confronted with somebody's picture that this is a non-criminal. You're not going to vote for that person. And you have a lot of people, they will be able to make their own decision. So there are so many things we need to work on. And so it's very important for us to focus on that legislative arm of government. I will ask Dudu. Dudu, I'm not seeing you if you're still on.
Perhaps Aisha, as an addition to the point you have made, I recognize that our laws are not progressive. We don't have a progressive constitution in the sense that it does not recognize the primacy of place of citizens in the governance of their country. Those provisions that relate to qualification and disqualification. I think it's important that going forward, as we continue to amend our constitution, some powers should be given to citizenship, to distill crime from non-crime. People who have facts, very verifiable facts about criminality of prospective candidates. The constitution should be able to empower them, allow them, to approach the court with the documents that they have, to seek disqualification or qualification, if we like, of these prospective candidates. If we cannot amend the constitution because it's more cumbersome, we can look at the provisions of the Electoral Act itself that deals with qualifications and all that deals with the issue of criminality and empower citizens in such a way. Look, we recognize the fact that the Electoral Act is not for INEC and for political parties. Where voters are absent, democracy becomes hollow. So if we don't give some level of legal powers to citizens to bring actions against prospective on the basis of their records, criminals in our country. And I also know that the question of meddlesome interlopers and busybody will become a problem. A certain legal bar can be created in subsections, or maybe provisos in the Electoral Act that says that for you to approach the court, the facts that you are bringing before the court must be on the basis of a sworn, verifiable affidavit. And you know that once you sworn to an affidavit that this document is true, if it turns out to be falsehood, you will be arrested and tried for perjury. For perjury. And we can do that in practical terms. Some of us have done some of these things. In 2012, when the oil subsidy thing arose, and a legislator in Kano was caught as a result of sting operation and all that. He is presently serving jail term in one of the Nigerian prisons and all that. I approached the Federal High Court in Abuja with verifiable affidavit named principal officers of the House of Reps who were involved in the syndicate of extorting money from those people whose names were mentioned in the oil subsidy scam. But because I got this document from a well-placed Nigerian who was a serving minister at that time, I was ready to put my integrity, my credibility, and my freedom on the line. On the line. But of course, the case was not heard on the merit because all parties settled the matters out of court.
Well, that's the Nigeria that we have. And so what we need to really focus on is getting those laws that are progressive and pro-Nigeria rather than pro-citizens. Thank you so much, Abdul Mahmoud Esquire, for this. It's been an amazing time. Before I go on, in the chat group, we've come to the end of today's program. I'm just putting in that. Let me just do this now. For those of you that were asking for yes, I have that. Labour Party registration, links to register. They have some for Imo, Kogi, and Bayelsa election, because those are the ones they are going to do. But when they send the rest in, I will also try to put them out. So Pauline, those are the links for all those of you on YouTube. I've also put in those links. It's been an interesting and really beautiful time out here, just listening and learning. And one of the things that is very important, I see a hand I haven't seen before. Basi, I would take that hand and that would be our final hand. I thought there were no longer hands that are up. So Basi, go ahead, please, and quickly ask your question or comment. Yeah.
Thank you so much, Aisha. Thank you for, this has been a very informative session with you guys. I just wanted to ask Barry, that in the law, it's just me trying to find out, is there any part in the Constitution that tells us about what happens? Like someone asked if there's in the event that there's a rerun, or the court decided that the certificate of return should be returned back to INEC and everything, and a fresh election be done. What happened? Is there any portion of the Constitution that talks about that provision, that provides for that scenario, or is it that it's just that INEC does? I don't know what happened. It's like we don't have any idea.
I'm sorry to cut it short, because I'm also running out of time as well. I have other engagements in the evening. Let's build three scenarios here. Three scenarios. Scenario one: if the court, here I mean the Supreme Court, as the final court of arbiter, or as the final arbiter, decides that the 2023 elections was not held in substantial compliance with the Electoral Act and nullifies the entire elections. What it means is that all presidential candidates who ran in 2023 will have to return back to the country to seek the legitimate votes of all Nigerians, regardless of their qualification. Here, under this scenario, if the courts hold that regardless of the issues raised against Bat as it relates to Section 137, we do not hold the fact that he has been disqualified by Section 137. Forfeiture ordered by the court in America does not hold water here in Nigeria. He was a qualified candidate and remains a qualified candidate. All presidential candidates will return back and face the country. Of course, Buhari is out of power. There will be a political and power vacuum in Nigeria. There is no vacuum under the Constitution. The Senate President, Dr. Ahmed Lawan, takes over the reins of power for 3 months. So it's expected that within that 3 months, the whole issue of petitions, appeal, elections, and all that would have been sorted out. That is one. Scenario two: if the courts hold that Bat was not qualified to have run the elections, either on the basis of the disqualification of his vice presidential candidate, or on the basis of Section 1371D that has been raised by Obi, that is in the forfeiture order imposed by the court in America over the drugs run, and his certificate of return is taken from him. The court will have to make a consequential order. The consequential order here will be this: that the person lawfully elected as president of Nigeria is either Mr. Atiku Abubakar or Mr. Peter Obi. Either or. Once it becomes either or, once it is the final arbitration, I'm using arbitration loosely here, order of the court, whoever the court declares as president of Nigeria is therein immediately sworn in as president of Nigeria. So there's no vacuum. There's no vacuum. Or the third scenario, that the court holds that the election was conducted in substantial compliance to the law, But Mr. Peter Obi was not qualified as a candidate of the Labour Party. Mr. Bola Tinubu, is hamstrung by Section 137, subsection 1D. What eventually means that it is Mr. Atiku Abubakar that becomes the lawful and legitimate candidate who won the 2023 election. So every scenario is at play here. So let's see what the court will come up with as its jurisprudence.
Thank you so much, Mr. Mahmood Esquire. It's been a pleasure and an honor having you here and speaking and learning so much from you. And I must agree, on YouTube and here, we have almost 1,000 people on YouTube watching, and everyone is really talking about how educative this has been. And so thank you so much for taking our time out.
So guys, we all know that the APC is interested in distracting the Nigerian people. They just want to distract us from the main issues. They know that there are so many things hanging on their head, so many things hanging on the head of Bola Ahmed Tinubu, hanging on the head of Shettima. We all know that they've got so many questions to ask. I tell you, their lawyers are going to have tough time in court, as in they are going to experience so many setbacks because of the nature of these cases. I tell you, Peter Obi's lawyers, they've done a good job in bringing up the petitions that they brought up. I tell you, it's not going to be business as usual. Even if our lawyers want to play foul, it won't be that easy for them, honestly. So guys, we are all looking up to the judiciary, all eyes on the judiciary. We are looking up to them. We are going to see how they are going to handle all these cases, and we are hoping that they are going to stand with the Nigerian people. They are going to give us back our mandate. Peter Obi is going to emerge the winner after this court suit, because it is clear that Bola Ahmed Tinubu will be disqualified. Honestly, his disqualification is very close. It's very, very close. So guys, please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section below. Thank you.